Hi everyone, can you hear me all right up the back there? Excellent. I was just, obviously today's presentation is about investment, mergers and acquisitions in the game development space, and I was thinking about the theme of this year's GCAP being ambition, and I think that a merger and acquisition type transaction is often the type of ambition that a lot of game developers have, looking for an exit at some point, looking for investment, building the games that they've always dreamed of doing. So the presentation fits quite neatly into the theme of this year's GCAP. My name's Cam Rogers Legal. Luke, late as usual. From Cam Rogers Legal. My details are up here, and I'd like to introduce my colleague in Sam Cottell. So I'm a digital entertainment specialist that focuses on video game development and distribution, and Sam is more a general commercial lawyer with a particular interest and focus on mergers and acquisitions generally. And between the two of us, we've worked on a number of transactions over the last few years, and we find that we have a good sort of working, we combine well together because I bring that experience in the digital game space, and Sam sort of brings the experience in dealing with the very rigorous negotiations of what these contracts often look like. So if you do want any more information about the way that we work together, or the types of transactions that we've done, please contact me, and we can take it from there. Okay, so what I wanted to do was just to give an overview of the type of things that we're going to be talking about today. So, look, to be brutally honest with you, a mergers and acquisitions presentation inside 50 minutes is almost ludicrous. It's such a vast kind of transaction, and it's likely to be the biggest one that you'd ever do in your commercial life. And there's just a lot of kind of parts to it. So what I wanted to do was to sort of focus on more almost the psychology of it and understanding why it's as big a transaction as it is. So, and that's designed to make you think about the outcomes and things that you actually want, and make sure that this is the pathway that you really want to go down, because it can be a lot of work. So we're going to be talking about the outcomes that you want. We'll have a quick look at the difference between an exit and sort of getting investment, and then we're going to start looking at this transaction, a mock transaction, over time. So we'll be I'll start to talk about some of the things to think about before the transaction kind of takes place, and then I'll throw to Sam, and Sam will kind of speak more to the specific stages of a transaction and how that all looks. It's a relatively small crowd in here today, so we were going to do questions at the end, but I think if you have questions, just sort of yell out, come up and speak on the microphone here, and if we might be able to go down a few rabbit holes that that interest people a little bit more, because it can be quite a dry topic. Okay. So the first place that I wanted to start was, as I was saying before, was really about the psychology of the process. Okay, so it's just such a large transaction, and there can be a lot of kind of false dawn. So the negotiation itself, the contractual negotiation, can take 3 months just in its own right. But before you even get to the contracting stage, depending on how you've arrived at this type of transaction, if you've utilised a broker, for example, it could have been going for a year before you even get to the point that you've even got a document on foot that you're trying to negotiate. And it can be a very laborious process, and quite a stressful one, because at the same time as managing the sale or the investment, you've got to continue running your business, and often a lot of the things that are going on are bound by NDAs and so forth, so they can't even be discussed to other people inside the organisation. So deal fatigue in particular can be a real issue, and in larger transactions that have got a bit more of a David and Goliath type feel to them, the acquirers understand that and sometimes lean into that a little bit to try and give themselves a better deal, in the sense that they would you just sort of give up after a while and start saying, oh no, we'll just concede that point because I'm sick of having this argument. So that's something to kind of bear in mind at the very outset. So on that point, the sale process is not an easy one. It's a time-consuming one, stressful one, but you sort of need to think about what exactly it is that you're trying to do. I mean, it's a transaction of this type generally is a transformative one for the company. So you need to understand what your rationale is for making the type of decisions that you are. Are you looking to build your team? Are you looking to build bigger games? Are you looking to cash out completely and sort of ride off into the sunset? You need to understand what that is and how that how that all looks for you, because that will instruct the type of transaction that you should be looking at. So if you were looking to to build the team, it would be more of an investment type situation. If you're looking to kind of get out, then it would be a sale type arrangement. And Sam will get into the specifics of how some of those things look a little bit later on. But it's important to realise that there are a number of options available to you when you're looking to kind of go down the path of one of these transactions. So knowing what your priorities are in advance is very useful and it will save you a lot of time and energy down the track. Because some of the things aren't immediately apparent. So, for example, if you're looking at cashing out and getting out of the company completely, well, the nature of the transaction might be that you're required to stay on inside the company as a director or as an employee for a period of time. So that isn't actually moving away from the company. So you need to be mindful about what are your priorities. Are you interested in those types of things or not? And you can cut some of those issues off at the pass as and when they arise. So yeah, it's important to understand that there's more than one way to reach and achieve a desired outcome too. So asking yourself, what are we trying to achieve? As I've just discussed, there's investment and sale. So investment would be the type of arrangement where an entity comes along and buys a percentage of the shares in the company, for example. And in this circumstance, the company is then sort of flush with revenue that they can deploy in different areas. And as the existing shareholders, you'll generally kind of maintain control of the company in that circumstance. Whereas in a sale arrangement, most likely you'll be no longer kind of in control of the company. As I say, you may be required to work there for some time, so you need to think about what's important to you there. And importantly, they both involve risk, and they might not be what they appear to be at first outset, so you've got to keep that in mind. As I was saying, understanding what you want before you start talking to third parties is really critical. If nothing else, you might only get one chance with this particular buyer to sit down for a meeting. And if you're thinking about investment or you're thinking about selling and you don't understand what this is, you don't know what the company's strategy is, etc., it just makes you a less interesting kind of target. So understanding your business and understanding what you want is kind of critical. And finally, just sort of, we're talking about the sort of formative stages here of how these transactions go down. It's always important to obtain tax advice early with respect to these potential transactions, because depending on how they shake out and what the value is of the shares and things like that, you need to get things in place to manage that revenue for the individual shareholders. So yeah, getting good tax advice early is very useful. So yeah, we kind of move beyond now from thinking about how the transaction should look and what your priorities are. And then we start looking at, okay, if you are to entertain one of these transactions, where do you start? Like, what do you need to do inside your own company? And it's really a matter of taking care of your backyard at first instance, because you need to understand that any particular buyer or investor is going to be going through the individual documents and relationships that exist within that company and sort of looking for errors to sort of de-risk the deal for themselves longer term. So making sure that everything is up to scratch, all your intellectual property assignments and so forth are really tied down, there's no loose ends, and getting all that stuff together so that a potential buyer, it's all tied up in a nice, neat little bow and they don't have any major issues that they've got to be worried about. The next thing to do is linked to tidying up your backyard, but you might have inadvertently entered into arrangements with third parties that have a change of control clause or some other contractual limitation that's going to impact the type of transaction that you're doing. And I think leases, commercial leases in particular, are quite notorious for this. They'll contain a change of control clause, which technically could block a sale. So it's important to have a look at these types of queries too. Publishing agreements in particular, they've often got change of control clauses too. I mean, in my practice, when I see change of control clauses, I try and knock them out as often as possible to keep things open, but sometimes you just can't do that. And so you need to be mindful of those type of arrangements and sort of figure out a way to get through that when the time comes. Yeah, so the other important thing to remember is that when this transaction comes through, this company itself is the asset that's being sold and the IP that it owns. So the transaction is not actually, doesn't take place between myself and the company. It's actually the shareholders of the company. They're the ones that are selling the company outright. So it's actually the individuals that are the clients in this case, and they're the ones that are actually selling the company. And so there's a number of warranties and things like that Sam will get into, talking about the substantive contract, that can be kind of personal in nature, and you just need to be mindful of that. And as a matter of kind of taking care of business, you need to understand that the structure that you might have in your company, be it unit trusts or something like that, may not be appealing to a third-party buyer, particularly if they're publicly listed and particularly if they're overseas and don't understand Australian trust law. And so sometimes before you can even entertain one of these transactions, you need to manage the shareholding situation and sort of declutter things so that it's nice and straightforward for a prospective buyer. So that's sort of the background to getting into these transactions. First of all, it's thinking about what you want to do and why you want to do it, and then it's about making sure that your company is as clean as possible to avoid any issues down the track. Sorry. All right, so then it's about getting started. So this is you've sorted out, you understand what you're trying to achieve, you've sorted out your backyard and the company's looking good. Now you start thinking about what type of company do you want to be working with, or be it a buyer or an investor. So you've got to make sure that the deal kind of makes practical sense, right? I mean, like, if you're going to be selling a company and you're a mobile developer and this large company, is a console publisher or something along that nature, that there's not a kind of a direct connection between the two companies, is it the right fit? What's their track record? If you're going to be swallowed up by them, you've got to make sure that the company is in good standing in its own right. So there's a bit of due diligence that's got to go back the other way as well. And in terms of how these transactions kind of work, initially when you're discussing the numbers and you're talking to people, that first phase is generally very friendly. It subsequently becomes more combative as we get into the negotiation of the long-form contract. And you've got to keep in mind that long term, if they've swallowed up your company or it's an investment situation, you need to be friends with these people. So there's a whole range of issues there around just relationships that's quite outside the scope of legal, but you need to make sure that the company itself that you're going to be working with, there is a compatibility there, and it's not just the business case, it has to be the personalities too. So that's something to keep in mind. So yeah, then the next phase, once we kind of get into, sorry, these slides are a bit, yeah, okay, there we go. Once we sort of start getting into the transaction more wholesomely, we start looking at things like due diligence. You've got to understand, as I was saying before, that all your paperwork and contracts will need to be reviewed. So there's no point hiding something under the rug. If there's an issue, it's worth kind of just being upfront about that and getting on the front foot and working out a strategy to resolve those things in the event that there is a problem. And the rationale for that is that the buyer or investor needs to understand what it is that they're actually investing in and buying. So they need to know warts and all where things are at, and they can make a risk call on it from their side about how they want to manage it. And to that end, due diligence, you often will see a data room. Well, in fact, every time you'll see a data room, and that sometimes is a really straightforward thing. It can be just as simple as a Dropbox folder where all of your documents and contracts are numbered and put in there for review. But sometimes they can be like a third-party platform that's kind of much more digitally secure. But you need to understand that all those documents need to be itemised, and it will be reviewed, and a range of questions will come back from the other side to kind of to look at and understand the basis for why certain decisions were made. So sometimes that can be quite a painful process, because you'll be looking at things like a privacy policy, and they'll say, well, that's your privacy policy as at today's date. Is there a potential risk there about your privacy management from 5 years ago. So they need to see every version of your privacy policy and make a call on that. So it can be a very substantive kind of process, and due diligence generally happens at the same time as the contract negotiation as well. So you find that you have multiple fronts suddenly. You'll be doing some due diligence work one day, and then you'll be looking at contracts the other day around the nature of the sale. So it can be a very kind of an intense process when you're going through that due diligence thing. The important thing to remember there too is that any of these potential risks that contain in your history will be used at some point in an attempt to ratchet down purchase price. So up front, you might have negotiated a number that you're very happy with, but once you get into contract and they start looking at these documents and they identify risk, there'll be mechanisms within the long-form contract to ratchet back purchase price. So the more work you can do in advance to make sure that those problems don't exist, the better off you'll be. The better off you'll be longer term. So that's sort of the psychology of the sale. That's the background, right from the very kind of beginning up to the point where you're now ready to kind of engage with the other side. And on that note, I'll hand over to Sam.
All right, thanks, Cam. So far Cam's talked about the bigger picture of a sale process and a lot of non-legal aspects to it which can't be emphasised enough. But I guess we're both lawyers, so we're going to have to talk about some legal documents. And I'll talk about what are the key sale documents in a transaction. Some of you may be familiar with these in other contexts or even in a M&A context. But for a sale, if it's a full sale or a partial sale with a new investor coming on board, you'll likely have one of these preliminary documents, which is a letter of intent, a heads of agreement, term sheet, memorandum of understanding, MOU, call it what you will. They're all basically the same sort of thing, where you would have had perhaps a little bit of due diligence might have occurred already, formulating the key commercial terms, a lot of focus on the price and how that's paid, things like that, perhaps other key commercial terms. We're talking about a 2 or 3 page, 1 or 2, 3 page type of document. So that's one of the key documents. It's usually non-binding from a legal perspective. So you might think, well, what's the point of having it non-binding? But because it's signed at a fairly preliminary stage, it's still a very useful document for the parties to have at least thrashed out to a certain degree the key commercial parameters of the transaction, put those on a page, and going forward that can be used as a point of reference for drafting the more formal long-form documents, as well as giving at least comfort that you've agreed on fundamental matters. Even though it's non-binding, confidentiality I've mentioned there, and Cam's already mentioned NDAs, that's an aspect which is likely to be binding, even in a letter of intent preliminary document. Or there may well be a separate confidentiality agreement. That's fairly common as well. And that may have been signed before the letter of intent MOU has been prepared or finalised, because even with these MOUs, they can themselves sometimes take a bit of time to be drafted, negotiated and finalised before they're signed. Exclusivity is another point, and I guess most of this presentation today is more from the sale perspective. So it's sort of pitched at people in the room here who might be looking to sell their companies rather than buying others. A lot of the principles are the same. But exclusivity here, what we're talking about is where the buyer in the transaction seeks a period of exclusivity during which the owners of the company will not entertain other potential bidders who might have interest in the company, or that they will cease discussions, etc. So that's an exclusivity period. That's relatively common, at least commonly asked for. Sellers generally try to refrain from giving exclusivity if they can, so they keep all their options open, and that helps their negotiating leverage during the transaction process. But perhaps an exclusivity period is acceptable if it's relatively short, and by short I mean weeks, not months and months and months. I mean, everything's negotiable, but a sensibly short period of exclusivity might be acceptable. So that's the preliminary stage. We then get to the other key document, which is your formal sale agreement. Now, Cam and I were chatting before about M&A process, and it's not about the lawyers. It shouldn't be about the lawyers. It's about you and your business and the transaction that you're doing. It should be as painful and as seamless and quick, really, as possible. You know, why not? But unfortunately, there's a lot of history and track record for legal agreements in a sale process of being dense and long. And that's especially the case if you have a buyer from overseas, and that is very common. Cam and I have worked on 3 or 4 in the last 24 months where overseas companies have bought Australian studios and they have prepared the sale agreement, and it's been very long and dense. And that's more of the tradition, style and custom for those countries. But in Australia, they're generally shorter rather than longer. Still a dense document, still a long document because there's a lot of issues to cover. The key agreement will be your sale agreement. If that's selling the company, that'll be a share sale agreement. Or if the company is selling its IP and key assets, that'll be a business or asset sale agreement. If it's been a partial sell down by bringing in a new investor, essentially to dilute the incumbent shareholders, that will be a subscription, whereby the new investor subscribes for new shares. And Cam's also mentioned preliminary stuff, looking at your shareholders agreement if you have one. A new investor will likely want to, depending on your shareholders agreement, but likely want to amend your shareholders agreement or perhaps replace it with something else entirely. That's very common. And the shareholders agreement itself is a completely different topic, but that can be very dense as well. One question that crops up quite often is who drafts these documents? Well, the sale agreement being the main transaction document, more often than not, is drafted by the sellers. It's their company, they're selling it on these terms, their sellers' lawyers will prepare it. But there's no hard and fast rule there. Often a buyer will prepare it. Sometimes that's the path of least resistance, and the buyer will want to use their document. The buyer might be a large company that's done multiple transactions. They have a specific deal team. They've worked up their own template sale agreements, which they like to use over and over again. And so that can be a way forward, and that might be a quicker way forward, quicker and perhaps cheaper way forward, but not always, because you can kind of bet your bottom dollar that it's going to be fairly comprehensive and biased, weighted in favour of the buyer rather than the seller. But anyhow, either way, once you get it, you get working, and we can work with whatever, who's drafting, doesn't really matter. There will be multiple drafts. So I guess you've all been involved in contract negotiations of some form. You probably need to take that to the next level with a sale agreement because they're very long, they touch upon so many issues, and I guess it's a fundamental transaction. So you'll often have 2 or 3 rounds just internally before the sale agreement might go to the other side if you're preparing it, or vice versa if they've prepared it and given it to you. We will review it, Cam and I will do some comments and advice for you, get your feedback, instructions, prepare a further version. You might look at that, bit of fine tuning, and then we table that back to the other side. This process can repeat multiple times, gradually whittling down the issues, and eventually the agreement will be signed. Negotiations can become protracted, and I'll just emphasise what Cam said before about the distraction and the deal fatigue factor. There might be some sticking points which weren't contemplated in the term sheet or the preliminary document, because that doesn't deal with everything. In order to get the deal done, someone needs to compromise or reach some sort of compromise. So that's where I get to the next point here about you've got to be pragmatic and reasonable. You might be faced with the benefit advice from Cam and I from a legal perspective and our practical experience and industry knowledge about what the real risk is here with some of these clauses, because you'll see a lot of provisions in sale agreements which are hard to understand, seems very unfair, etc. But got to be pragmatic. Not to say that there aren't provisions where you need to really stick to your guns and eventually sense will prevail and perhaps a compromise will be reached. But you do need to take a balanced approach. That's another thing that occurred to me with this presentation and the work that we've done together on several deals is a lot of owners of game studios and businesses like yours may not have had a lot of experience doing M&A work. And that's fine, but you've got a lot of experience with your own business. And the fact that you've been approached or someone's wanting to buy you is a reflection of your success already, really. Doing the transaction is another significant milestone. But you need to really back yourself and follow your own instinct. So sometimes you might not be familiar with all the details in these contracts. What does all this mean? But you've got advice. Cam and I are here. You might have a tax accounting assistant as well, hopefully. And you need to make a decision on various topics. But as I said, gut instinct and your own sense of things is a very good guiding principle. So don't feel steamrolled. That's one thing that we've encountered several times and part of the deal fatigue. And there's a time for deal fatigue to just over it, just concede it, just move on, etc. That's fine. We can understand that. But there are some things where you should, not roll over, and you should stick to your guns, and usually common sense will prevail. Now, so they're the key documents, and we thought that was worthwhile to explain. There are lots of other documents as well that are ancillary to a transaction, but they're the main two big ones, most important ones. Now I'll talk about some common issues. There are a lot of things that get dealt with in a sale agreement, and this is not the time or place to go through all the clauses and topics that are dealt with in a sale agreement, but some of the most common ones. So a non-compete or restraint of trade, probably aware of what they are. You've probably seen them in employment agreements. So it's basically where the founder of a business or the seller of a business or company agrees not to compete or undertake similar activities for a period of time after they've sold the company. That's to give the buyer the benefit of a clear window where they can run it and get the value of what they bought without being undermined by the former owner. So that's very common. That can be a period of time from 6 months after the sale to 3, 4, 5, 6 or more years, depending on the context. But that's a very common thing. So as Cam said, if you think you're going to go into this to sell this business, what's your game plan? If the game plan is that I'm going to set up something else, well, you want to think that through. Is that going to work? Because I'm likely to be subject to a restraint of trade. The purchase price, that's the next point I've got on this list here. Bit of a no-brainer that that's going to be dealt with in the sale agreement, but usually relatively extensive provisions will be dealt with in the sale agreement on the topic of the purchase price. So ideally you would have a very simple transaction. If the purchase price is fixed, it's X millions of dollars, it'll be paid in one lump sum or perhaps a deposit and then on completion. That's fine, that's nice and simple. But many times purchase price formulas and payment arrangements are more complicated than that. So that might be because there's an earn-out arrangement, and I've mentioned that there, whereby, yes, we'll pay you this much up front, and we'll pay you some more later on, but that's only if the company performs to these thresholds, earns this revenue, releases these games, other milestones, and there could be more than one of those over a period of months or years into the future. So all of that adds to the complexity of the legal agreements. A holdback is essentially a similar sort of thing where you're getting paid some of the purchase price now, perhaps some of it or the balance of it on the first anniversary or thereabouts. These are all fairly common. Earnouts are particularly common in the gaming industry, we have found. They're probably more favourable to a buyer than a seller. They are somewhat prone to disputes in the sense of how do you calculate the amount of the earnout in the future, as well as fights, if you like, in terms of, well, I would have made the earnout, but you didn't do what you said you were going to do, and it's your fault, not mine, and I should get it, not get it, etc. Those sorts of disputes can and certainly do occur. So they lead to Cam and I, when we do a decent earn-out, to put in a fairly well thought through approach to try and protect your interests as much as possible and make things as certain as possible. As Cam's already mentioned, third-party consents. So you might have a transaction where you can simply just sign it up today. We're going to complete it next Friday. That's great, nice and simple. There might not be any third-party consents that are required, but more often than not, there will be some sort of third-party consents required. So you'll have clauses in the contract which deal with, yes, we're signing it today, got these conditions, satisfy the conditions, and we'll complete shortly thereafter. There can be all sorts of conditions. They could be a due diligence condition, although hopefully due diligence is done by the time the formal sale agreement is signed. It could be a board approval. It could be some other regulatory approval. ACCC merger clearance approvals are pretty uncommon, but that's a possibility. Foreign Investment Review Board approval, again, you need to be a fairly decent sized studio, and Cam, actually, we haven't done one of those recently, but that's another possibility, particularly with overseas studios being interested in Australian companies. But leases, equipment leases, property leases, key contracts with change of control clauses, usually there'll be a process for seeking those consents up front before completion occurs, or that they'll be obtained afterwards. New employment agreements. That's another, that will be a separate agreement, but more often than not, when a company is sold, the key staff will be retained in the business for a period of time. It is possible, and we have done some where the founders, original shareholders, main shareholders sell it and they just walk away. That's rare. That's usually where they've been very clear that that's what they want to do. That's been clear from day one. The buyer's aware of that, and they can run it themselves, and there might be some transition period leading up to that. But more often than not, there will be a requirement for the key staff to continue on in the business, and that's in many instances why the business is being bought, for the staff. So a new employment agreement, likely to be on the buyer's standard terms. Now we're getting to some more common issues or topics that are dealt with in a sale agreement, to give you a bit of a flavour without getting too dry and bogged down on legalities of these topics. But I guess for the uninitiated, you'll come across these in a sale agreement, or they might be contemplated or referred to very briefly in a letter of intent MOU at an early stage, about warranties and indemnities. You know, it might be very early on, it might say, well, the sale will be subject to warranties and indemnities that are customary in Australia. What does that mean? Well, good question. I'm going to tell you today what a warranty and indemnity is. A warranty is, maybe put up your hands if people in the room already know what the warranties and indemnities are. Quite a few people, that's good. But for those that don't, but when the owners of the company sell it, they will give warranties to the new owner. They could be warranties that the company's incorporated, the company owns these assets, it owns the IP, it's the registered holder of this license, it's not in breach of contracts, has this permit, blah, blah, blah. A lot of warranties could be given about a whole range of topics. I think one of the, and you know, that might go for 2 or 3 or 4 or 5 pages, but realistically they can go for a lot more, and we're involved in one recently where Cam did a lot of the heavy lifting on 30 pages of warranties or thereabouts. So yes, brace yourself for that process, but we can work with you to manage that as much as possible. Indemnities, again, some of you are probably familiar with those, but a sale agreement will likely contain some indemnities. And that's usually where there's a specific risk that's been identified during due diligence that the buyer is not happy with. So if they're buying the company, normally that company will be transferred with every single liability, historical, known, unknown, in it, and the buyer will take the company as is. That might mean that there are some liabilities that have been discovered in the company because it's breached a contract, or it's has some debt, or there's a litigation, or there's some issue that the buyer is not happy with, and the buyer will say, well, I'm prepared to proceed with the transaction, but I don't want to take the responsibility for that matter. So that will be dealt with by an indemnity clause in the sale agreement, which will basically have the current owners of the company promising that they will be responsible for whatever loss or damage might come from that particular matter in the future, in very short-term summary words. The next thing on this list here is the disclosure letter, and I'll talk very briefly about that. People might have come across that before. It's a separate document. It's usually done in conjunction with the warranties. As are most of these topics on this page, they're related to liabilities of the sellers. A disclosure letter kind of works in tandem with the data room that Cam has already mentioned. So you have a data room, Dropbox or tailored platform for M&A deals. You've got a whole lot of information there. The buyer has access to that. It can see it, can review it, forms its own view. The general position is, and the sale agreement will reflect this, to say that, well, if we put information in the data room, then no matter what the warranties say, you can't claim against us if we've told you the truth of it and it's quite clearly evident in the data room that we told you the truth. A disclosure letter is an additional mechanism for doing that. So towards the end of a transaction, the sellers might prepare a disclosure letter which essentially will say, here are the warranties. For that particular warranty, we are disclosing, say, rather than being in compliance with our contractual terms, we are in fact in breach of this one here, and the consequence could be this. So you've been upfront. Again, it's to do with being upfront and being transparent. Joint and several liability. Won't talk very much about that, but that's a very fundamental one, because more often than not, the companies that we come to help, they have more than one shareholder. They've got maybe more than one founder, early investors, staff and employees. They all hold shares. They're all going to have, if it's going to be a share sale transaction, they're all going to sell their shares to be 100% to the new owner. Often we come across a situation where the buyer will want the sellers to be jointly and severally liable for all of the seller's obligations. So joint and several liability is where one of the sellers can be responsible and sued for 100% of the buyer's loss and damage, even though that particular seller might only own 1% of the company. So the better position, I mean, that's one example. It could be 30-70, could be whatever it is, but the better position that we usually try for, and most of the time are successful in getting, sometimes we have to back it with a contribution agreement behind the scenes, but it's to have your liability limited to your respective proportions. So if you are a founder and you have, say, 40% of the company, you should only be liable for 40% of the buyer's loss, that sort of thing. Limitation of liability, again, a lot of these things do touch about liabilities, but you'll find that the sale agreement ultimately is about allocating liabilities between the parties. These are some of the common limitation of liability provisions. So it's very common for a sale agreement to limit the seller's liability for certain things. So you'll have a minimum claim threshold. So that's kind of where if the buyer has a claim, it has to be above a certain amount, 10, 20, 30, 50, 100, a million, whatever the threshold is, appropriately scaled to your transaction. Unless the claim's above that amount, we're not liable for it. A maximum cap. So you can have all these claims, you can come to me, okay, I've sold the company, something went wrong, I'll be liable, but only up to a certain amount, a maximum cap. And often that is set by reference to the purchase price. So it could be 100% of the purchase price or some lower percentage of the purchase price. There will also be time limitations, and that gives the sellers some comfort that unless the buyer brings claims, and these could be a warranty claim, an indemnity claim, purchase price adjustment claim, whatever it might be, unless they bring the claim within 1 year, 2 years, 3 years, whatever that period is, and you could have more than one period depending on the type of claim, but unless the claim is brought within that time period, you're not liable for it. And there can be other exclusions as well. Cam?
Yeah, I mean, at this point, it's probably good to throw to the audience. Has anybody got any burning questions? I mean, that's a fairly breezy overview. But we're just trying to... excuse me. give you a sort of a flavour of the complexity of this stuff. And it's at that time of the conference where I start losing my voice, unfortunately. But yeah, does anyone have any questions? Yep.
Great presentation. Thank you very much. Really great information.
Thank you.
It's all very top level.
It is very top level. We might have the hour. We've got sort of 40 minutes.
Hello. Yeah. Thank you very much for the presentation.
Pleasure.
I'm just wondering around dilution and things like that. So you were talking about someone coming to just buy the company outright or merge with another company versus someone investing. Do you get problems where one of the shareholders is like holding out or being difficult about diluting?
Sometimes you do, and that's where a shareholders agreement is useful, because when you've got a company set up, there's no legal requirement to have a shareholders agreement, but that's the best place to address these types of issues. So that becomes often in a company you have tag along and drag along rights, so that if the company is being sold, people can't hold out and expect a bigger price, and conversely, if you're a minority shareholder, thank you. There's protections in that document so that somebody can't buy the first 70% of the shares in the company at price A and then subsequently try and buy the remaining 30% at a much lower rate. But that sort of should be managed in the shareholders agreement as opposed to the actual share sale transaction itself.
And hopefully you would have a shareholders agreement before you're approached by someone else, and that will set out how decisions like that are made, like how is the company to be sold, who controls that, who ultimately has the say on that, and can you drag everyone else along with you? I think you were saying dilution and maybe partial sell down. Well, that's not selling the entire company. That's maybe someone selling some of their shares, or it's either the company, no one's selling their shares, but the company's going to issue some fresh shares.
Yeah.
So a shareholders agreement will typically also deal with the process for issuing new shares. Do they need to be issued to all of the shareholders first on a pro rata basis so they can have an opportunity to maintain their percentages without being diluted? And if you don't take it up, then it can be offered to someone else externally, preemptive right if you like. It's certainly relatively common. I think more common in our experience, we did do one actually with a large international player who came and they bought a minority stake of about 40%, which was by way of a fresh issue of shares together with some sell down at the same time. And that worked out very well for that client. They were able to realise some of their investment by selling some of their shares, so they got some money in their pocket. The new investor put some money into the company directly so it could grow itself as well. So you can have a combination, doesn't need to be one or the other.
Yeah, there's a number of different ways that this can all be carved up, and that's why I was saying at the beginning of the talk to understand what it is you're trying to achieve, because there can be more than one way to kind of get to that goal.
I have a question real quick, because I don't know how relevant it is to everyone here, so apologies. Company based in Australia, purchasing a company based in Singapore. Based on your experience, are there any gotchas or risks to be aware of when a transaction like this happens?
Well, I think the thing that immediately springs to mind to me there is really kind of the taxation piece on that, whether or not how the deal is structured and whether or not that gets caught up in some sort of double taxation treaty and withholding tax regulations and things like that. So again, I would be speaking to a good accountant about those types of things at the outset to understand how the revenue flows and what that looks like for you. I think the second thing there would be, what jurisdiction is this arrangement going to be governed by? So presumably if you're an Australian company acquiring one in Singapore, we're drafting here, but they're there. What's the interplay of how this contract sits, like where do disputes get heard and things like that? I mean, did you have any comments on that, Sam?
Yeah, no, that's an important one. I don't, off the top of my head, no immediate gotcha type of things occur. There's no reason why an Australian company can't buy shares in Singapore, and let's just say it's an unlisted private company in Singapore. There could be foreign investment approval which is required depending on the rule of Singapore, and I'm not able to advise on that. I don't know that off the top of my head. It might not be that there's none required, but that should be considered. they could have local directorship requirements, they could have other requirements that are specific to Singapore. But in terms of actually buying the shares, I don't think that there would be any specific requirements. The governing law and jurisdiction of the transaction, that could be something to be negotiated, because if you end up in a dispute, do you have to have that heard in a Singaporean court, or do you want that in your own backyard, or maybe go somewhere neutral? I think Singapore law, so Singapore corporate law, is very, very similar to Australia's. I think it's probably, in some respects, being modelled off our Corporations Act in Australia, if that is helpful. So it's relatively similar. I mean, US law, UK law, they're all similar, but I think Singapore is fairly close to Australian law. So, I mean, as generic as that answer is, no, yeah.
Yep.
Could you give us a little bit more information about how you how a purchaser retains the senior staff? Because like so many companies at the moment seem to be being purchased for the team.
Yes, that's right.
So I was kind of interested in like how it happens and also how deep it can go. Like I kind of understand how it might happen right at the top, but if you're after trying to keep a bigger team of senior people.
Yeah.
In the company,
I think, well, there's a couple of different ways that would happen. I think that sometimes the acquirer can be quite prescriptive about that and say this portion of the purchase price has to go to senior staff. But other times, and Sam was speaking about earnouts and things like that are in the contract. As the seller, you're kind of incentivized to keep your staff there because you have to hit these metrics in order to unlock future payments. So sometimes it kind of takes care of itself. But, in most of the transactions that we've worked on, the sellers are decent people that want to reward the staff for getting them to this point, and they've generally managed it themselves. But on some transactions, the buyer can be much more prescriptive and insist that a portion of the purchase price goes directly to those staff to incentivise them. Because you're exactly right. Like at the moment, studios being bought for their capability in manpower. You've got to be able to retain that staff, and otherwise the deal wouldn't make sense without it.
Yeah, so I would add to that, like the earnout, that's important for those who own shares and are selling their shares. So if the earnout targets are achieved in the future, they'll get paid more money. So yes, I'll stay in the company because I want to make sure I get that target, so I get that money. But that's usually just for the senior staff who own shares and have sold them. So the earnout is one way that that's done. Another way is the non-compete restraint clause in the sale agreement. So, yeah, you can leave, but you can't go anywhere else for a period of time. So why would you leave? You could if you want, but you can't go and work somewhere else or set up your own. New employment agreements will usually be done for the senior people, and that might not just be the sellers. It could be staff who are senior but are not involved in the transaction. It could be a requirement that they sign up to new employment agreements. And that might be done in conjunction with the sale, or it might be something that it's best handled a bit more softly and transition to that in a period of time after we've bought the company. Depending on who the buyer is, they might be able to offer an employee share scheme or shares in a listed company. That's often seen as a reward for staff, and that can be made available quite broadly to all levels of staff, potentially. Depending on who the buyer is. So that's another thing, participation in an employee share scheme, like a listed employee share scheme. As Cam said, sometimes the sellers who have sold out, they've received a significant amount of money. They might give some money, they might give, in the most tax-effective way, some money to the key staff who haven't been a seller, they haven't received a sale, but they'll be rewarded in some way. And sometimes the purchaser will want some of the money to somehow go as bonuses. Like it's not, if you're selling the company, the employees are still there. They're still employed by the same company. The company's just got new owners. But the seller and the buyer, they might agree that, well, instead of the sellers getting paid this much money, they'll get paid less because part of that will go into a pool, which will be a one-off bonus. Welcome to the new world of the buyer's business. Great to hear, here's a bonus, or here's a pay rise. It is an opportunity for pay rises to occur. A lot of contracts might have, we can just terminate your employment, or you can resign on a very short-term basis, so you're not locked in. So there has to be other things to make people want to stay.
Yeah, and I think the interesting thing there is as well is that, you know, you've sold the company, it's no longer yours. Somebody else is in charge now, so they can hire and fire and do what they want. And this is the complexity that we faced in drafting and, you know, negotiating these contracts, is trying to future-proof across years. So if that hitting those earnouts, for example, it's a difficult threshold, it's not something you can just trip over, like that you need people to be working on things. We need to work on that share sale agreement and make sure that they're on the hook for doing these things to enable you to hit those thresholds. So, you know, the more earnouts and the things that get triggered and unlocked over time just adds an extra layer of complexity, because we've got to make sure that objectively these things can't be gamed in the favour of the buyer in a year's time when management changes and things like that. So the company is no longer yours, and yeah, you've got less control overall. So you've got to be as pragmatic as possible about getting the outcomes that you desired at the outset. I think that's kind of, we're getting wound up now. So I think.
One more question.
Yes.
I was curious about the valuation process, and specifically how, in the process of coming up with the figure for the sale, companies figure out intangible assets like the value of, in our case, in the games industry, often code libraries, or the value of the brand and the brand equity.
Yep.
Yeah.
So the question was just about valuation and how you kind of actually arrive at a number. I mean, that's kind of accounting magic. I can see Luke Henry at the back of the room. He can probably speak to that better than I. But look, it is based on like revenue targets. It's based on what they can see at the quality of the IP that you've got or the technology that you've got. There's a number of different ways of doing it. I think that, you know, when you go through one of these processes, you're going to be spending a lot of time on Excel and doing modelling and pulling things apart and working out, if you put money in here, what does that mean in 2 years' time, 5 years' time, 10 years' time? How do we manipulate these outcomes? Where's the revenue coming from? Where's the cycle of the game development process? There's a whole range of things that sort of all get thrown into the pot, and then eventually, you know, you come up with a number that works, and that's generally how it's done.
Yeah. Look, Cam and I are both lawyers. That's essentially a non-legal question.
It's an accounting question.
How do you value the company? I mean, Cam especially, his knowledge of gaming IP is phenomenal, and I've worked with Cam on a lot of transactions, so you kind of get a sense of, does that seem about right? You know, it's not for us to advise on, and we don't advise on.
To negotiation about that price if the two parties feel very differently about what that figure is.
Yep.
Like, is it a difficult process to resolve?
Yes,
Or is
it can be.
It can be.
It can be a case that people just can't reach an agreement.
Well, this is why you sometimes get to a point where they say, well, we can only do X amount in cash, but then we'll give you the rest in shares, or earn out, because that implies that there's a threshold of revenue that the project is making. So, you know, if it hits that, then they've got extra cash at that time to give you more at that time. So, yeah, there's more than one way to skin a cat, and sometimes you see multiple. It's very rarely just sign on the dotted line, here's the cash, and you're done. It's usually some sort of combination of all these things.
Like the earnout can be sometimes used to bridge what's called the valuation gap. Like you might think I'm worth this much, the buyer thinks, well, no, you're worth that much. But if you do all these things and the blue sky comes out just as you predict, then I'd pay you a bit more. And so the sale agreement and the price could be agreed that it's this much plus this, but only if X, Y, Z occur. The valuation is not just on the revenue or the profit. It could be strategic for a whole lot of other regions that are specific to one buyer and not other buyers. You've got to look at what's the market happening. Like, you know, it could be that people are just paying huge amounts of money for studios, where it's different to if you're buying car manufacturing plant. Like, there's so many factors that go into evaluation. Yeah.
Yeah, thanks. Great answer.
Any other questions?
I think we'll have to wrap up.
Yep.
But I mean, Sam and I are here for a few more minutes. If someone's got questions, they can approach us after the session and we can talk to you then. Thank you.